with Mark and Darren, both specialists from Croner. They will joining us today to help us understand certain topics COVID-related, which are important for the employers to know. So we will discuss changes that are going ahead from the 1st of April and topics such as how to make your workplace COVID secure. Hello, Darren. Hello, Mark. How are you today?
Very well. Good morning. Good
morning.
Morning, Thomas. And good morning, everybody. Yeah, I'm looking forward to it. It should be very good, Thomas.
Sure, absolutely. So, Darren, first thing, let me just, you've mentioned to me earlier on when we talked about important changes, good work plan, if I'm right, but correct me if I'm wrong, that is coming on 1st of April, and that is something that employers need to be aware. And as we are right now at the beginning of April, I think that we can start with that topic. So what it is about?
So Mark is one of our HR experts. So Mark is very good on the good work plan. So I'll hand this one over to Mark. That's okay, Mark?
Yeah, no problem at all. I'll happily cover the good work plan. It actually came into force on the 6th of April last year, so it's already in place now. Okay. Essentially, what it's done is rendered contracts out of date overnight. So now employers need to be very cautious about issuing contracts to employees from this point or from the 6th of April last year forward. We need to make sure that those contracts are, one, up to date and good work compliant to make sure that they actually protect the business. So the main changes on the good work plan was, it changed contracts to become a day one entitlement. So previously we had about 8 weeks grace period to actually provide documentation to an employee, but now we have to have that ready on day one of employment. So all documentation needs to be compliant and up to date when that employee begins and needs to be provided to them on that first day. Okay. As well as that, it's updated what needs to go into the body of the contract. So one example would be family-friendly entitlements. Now, most employers would have those in their handbook, in their policies and procedures, things like maternity leave, paternity leave, shared parental leave, adoption leave, and shared or parental bereavement leave, which also came into force on the 6th of April last year. Now these clauses need to go into the body of the contract itself. Employers just need to outline what an employee will be entitled to under those leaves. So what they'll be paid. They're going to be paid statutory minimum, that's fine. We just need to outline that in the body of the contract. As well as that, you still have your policies in place, excuse me, that would just outline, how they apply for these things, what they need to provide you when, what the company will take into consideration with these types of leave. But we just need to make sure that those clauses are in the body of the contract itself. What else changed under the good work plan? We had the break in continuous service. So previously that would be 1 week with a weekend either side. Now that's become 1 month. So if you're breaking someone's employment, they need to have not been employed by you for a month, and there must be no prior arrangement for them returning. As well as that, under the good work plan, all benefits that an employee will receive must be outlined in the contract itself. So again, this is where you may have these things in separate policies. You may have them sent out to an employee on an email, for example, or in your handbook, which is fine. We just need to make sure that what needs to go in the body of that contract and make it a compliant contract is in there. One of the other updates was holiday pay. That also came into force with the good work plan. So how holiday pay is calculated. Before the 6th of April last year, you calculated over a 12-week reference period, which has now been extended to 52 weeks. So if your employees' hours vary for whatever reason, let's say you pay them commission, bonuses, or they have overtime or whatever, we just need to make sure that we are calculating holiday pay correctly and that is referenced as well in the body of the contract. I'm trying to think what else changed under the good work plan. It was a big document. Probationary periods as well was one. Usually you'd find employers do outline that in the body of the contract, and that's great. But if a probationary period is going to be extended, I just make sure that you are outlining in the contract how long that will be extended by. So you've got a probationary period of 6 months. If it's to be extended, it'll be extended by a further 3 months, and that's outlined in the body of the contract. And the emphasis on that contract is, and it's the foundation to that employment. It's the relationship that you have with that employee. So as well as needing it to be spot on and secure, you also want it to give you some flexibility as well in various situations. So it is important that employers do do bring it in line with the Good Work Plan, and those were the main changes that came into force with it.
Thank you for that, Mark. Well, I have a question. Does it apply both to new employees and also an existing employees? So, I mean, do employers need to update contracts, sign new contracts with employees, or would it be just an update of a handbook in that case?
So any contracts that you issue now will need to be Good Work Plan compliant, or any contracts that have been issued 6th of April last year, because we are almost a year in, or pretty much a year into the Good Work Plan. So we want to be cautious of any contracts that have been issued since the 6th of April last year. I mean, it's an interesting question. Do employers need to update previous contracts? Now, we always recommend that you keep contracts up to date and in line with employment law. So our recommendation would be that, yes, you do update previous contracts. And the reason being is, any claims that come, you're defending an employment tribunal, you want to show to that judge that you're fair, reasonable, you're transparent, you care about employment law. And what we can't do in that situation is say that statement that we're in line with employment law and then put down contracts that are out of date. It puts us on the back foot with making those remarks. So legally, updating in line with the Good Work Plan, anything from 6th of April onwards, you must do. Anything prior, it's advised that you do update it in line with it.
What if an employee would refuse to sign a new contract, even though that employer is legally obliged to update it?
We'd look at that on a case-by-case basis, essentially. The big question would be, got some background noise there. I think the big question would be, why? Why is that employee refusing to sign that contract? What reason is it? Do they feel that you are trying to change their express terms in the contract? Are they not happy with the terms of the contract? Because essentially, when you're updating contracts to be compliant or more compliant with the law, you're not changing the fundamentals. You're not saying, we're going to pay you less, we're going to take away your holiday, we're going to shorten your notice period. You're saying, here's a new contract, it's the same terms, but it's more compliant and has compliant wording in it. If they refuse to sign it, I mean, in an extreme situation, you may find that once you've gone through a period of trying to assess their concerns, that you send it to them with a letter, make very clear, look, these are the terms and conditions that we're working towards. We take it that you accept them as you've accepted employment with us. But before we get to that extreme point, you really do want to address those concerns, because not addressing those concerns can obviously open the door up to other issues as well.
Right, and I think that will move us, closer to the topic of, COVID vaccinations and so on. But first of all, because that will be a big update in terms of employment, I think some employers started to, in the media, for example, they started to notify that they would require their employees, newly joined employees, to be vaccinated. But the big question is, of course, about those who were working before, and if the updated contracts could include some clauses. Before maybe answering that question, I think that we can talk a little bit about, COVID-19 and the fact of making your workplace secure. So what recommendations would you have for employers?
So health and safety, obviously the laws change. It's a very fluid piece of law, but the main thing to have for every business is a COVID risk assessment. Now, your COVID risk assessment, this is where the law is a little bit grey, because under the Health and Safety at Work Act, it says that if you've got less than 5 employees, you don't have to document your health and safety. Okay, but we always advise, how can you evidence that you've done your risk assessment if it's not written down? So once you've done the COVID risk assessment, then you can then display the poster. So it's a blue and white poster, it's a government poster. But when you do the risk assessment, you need to think about the general thing. So if I look at the poster, it talks about demonstrating cleaning, hand washing and hygiene procedures. If you've got any employees working from home, that's a separate piece of legislation that we can come on to. And then also you've got to factor in the social distancing. If you can't social distance for the 2 metre, what have you got in place to mitigate that? If you've got to be, say within one metre. And then really you should have a COVID policy in place as well to accompany that. And that's probably the best thing to do. Now the health and safety executive have got quite a few million in the bank from Boris to do inspections. they're currently doing COVID inspections in hotspots. So as we speak today, Manchester is a hotspot for them. But I'm not aware of any prosecution so far where I mean, generally the health and safety executive are quite good in terms of they will write to a business and say, you know, we'll be coming in, so, you know, this time next week, for example. But I think it's quite fair to say there's been no prosecutions at the moment, but that might change. But it's good to have this in place. But you know, the biggest thing, Thomas, around this sort of thing is your insurance. If you go to make a claim on your insurance and you don't have these things in place, then it gives the insurance a get-out card, and they might not cover the claim.
Right, I see. But so COVID risk assessment, that I suppose is well, specific for different type of businesses, right? So it would have to be created individually for, well, particular business. Is that correct? Yes.
Correct. Yeah.
There's no like general guidance. I mean, there's no like general guidance or rules that you could apply to all the businesses and therefore be compliant just by printing a few pages of, you know, of some guidance that your employees would sign.
Yeah, unfortunately, not. As you're right and say, it's got to be tailored and it's got to be bespoke to that business. Otherwise, everyone would just be downloading it from Google, and away they would go.
And there is a different work assessment for working. I mean, the different risk assessment for home working you've mentioned. So that companies which require their employees to work both on site and at home or in a hybrid mode, they should have two different types of risk assessments. Is that the case?
That is the case. I mean, this is nothing new. If you've got employees working from home for a considerable amount of time, then there should be that should be factored into your compliance. But if we look at home working generally, so if you got it's the display screen equipment regulations in the UK that kind of like govern this. So if you look at an individual in an office, if they're in front of a PC for a long period of time, there needs to be annual sort of workstation assessments.
Mm-hmm.
The same would apply when the employee is at home, but obviously the employer is not going to go to every employee's house, so therefore you'd give them effectively a checklist, and then based on that checklist, then obviously you can make the necessary adjustments for that employee. But I say that is something that whether you've got one employee or 5 employees, it doesn't matter. That needs to be written down.
Right, but when it's written down, like I understand, employee agrees with the risk assessment, but you know, the key question is because it's not really enforceable by the employers, isn't it? It's really up to the employees to you know, be compliant during the time when they cannot be really supervised. So you know, I assume that this well, you can well, as an employer, you want to minimize your risk of potential claims, but is it technically possible that without those risk assessments, your employees could, for example, claim for the accident at work, which actually happened at home?
Quite possibly, yeah, quite possibly, and it all goes back again to the insurance. You know, we're seeing more and more now. You know, new clients coming to us that have got, you know, maybe 2 employees, but the insurers are saying, we want to see your risk assessments, we want to see your health and safety statement, we want evidence that you shared this with your employees. So I think we're seeing more and more now that the insurers want things written down as opposed to you know, them just doing it verbally, I guess. But yeah, you're quite right. As an employer, you know, you know, it's the reverse burden of proof. You, the employer, have to comply with the law, but you can only do so much, and that's the piece that you need to get right. You need to be able to demonstrate that you've done as much as you possibly can, give the correct guidance, but ultimately, the employee's got responsibilities as well.
Right, that's okay, but it's good to understand that employers, by creating this risk assessment, by sharing this with employees, but by making sure that employees are trained, that they're signing risk assessments, that will prove that employers are doing everything they reasonably can in order to minimize that risk, right? So that is what would be required from the employers. I just wonder, because we actually touching this subject of home working, working from home, creating your workplace COVID secure. And the question that I hear quite often from my clients, there are questions related to shielding, vaccination, and basically how employers supposed to react to those topics. For example, I've been asked this question: can employee be dismissed if he or she refuses to go back to work if they are in, let's say, a risk group? Some people are shielding because of their underlying health conditions, and the guidance from the government, I think, right now changed, and those employees should be returning to work when they are required, but there's lots of concern around this, and I just wonder if you, Darren, or Mark could answer that question for me.
Yeah, I can cover that for you. It's not a problem at all. I mean, shielding is coming to an end in England and Wales as of today. Excuse me. So as of tomorrow, we can expect shielding employees back. Now, it's an interesting question. You say, what do you do if an employee refuses to return? And it's really not as simple as, well, if you don't come back, we're going to dismiss you because you're refusing to work, because there's so many variables we need to consider. I mean, the first one to consider, obviously, is why is this employee shielding? They obviously have an underlying health condition, which could easily amount to a disability. So what we don't want to happen is force them to do something which is a detriment to them and their disability, because that can easily amount to a disability discrimination claim. As well as that, we need to listen to any concerns that they have. I don't know if you've ever come across Section 44 of the Employment Rights Act, but that basically highlights that an employee should not suffer a detriment for outlining a health and safety concern, or the employer should not refuse to act. So with that in mind, if an employee's shielding comes to an end, and we would advise clients that they send a letter out to their employees to say shielding comes to an end and we expect you back, and let's say this employee says, no, I'm not going to return, we need to pounce on that. We need to look at what's the issues, what's the concern, because they may have a concern with the health and safety, and they may be worried about coming back to the workplace. And let's face it, justifiably so. We've never been in a pandemic before. They've obviously got a health reason as to why they needed to shield in the first place. So it'd be justified if they were concerned about coming back in. And this is where we see employers fall short all of the time, because employers will think, I've done my risk assessment, I've done everything that Darren's outlined there, I've done everything, I'm COVID secure, and therefore, there's no risk with the employee being here. We expect you back to work, come back to work. Now, in order to avoid a claim under Section 44, we need to address that concern. We need to deal with that concern correctly. So with that in mind, we very much need to do what we can to meet with this employee and listen to their concerns. Even though their concerns may not be justified in the workplace, that you may be COVID secure, we need to listen to them and find out why. What's the issue? What's the health and safety concern? Let's document that we've attempted to understand it. Let's document that we've tried to resolve it. And then that protects us more if they attempt to make those claims. And you can imagine that claims under Section 44 have rocketed over the last year, especially since when the teachers were supposed to return. The union said to teachers, look, just quote Section 44, quote that you're concerned about health and safety, and you can't be suffering a detriment for refusing to come back. So it's a hot topic, and it's an area that we're having to contend with a lot at the moment, especially now when shielding comes to an end. As well as that, the disability discrimination element and how we mitigate that side of things down. And of course, with any underlying health condition, whether we're in a pandemic or not, we need to be seen as employers to try and understand what the issue is, to try and understand their concerns, understand how we can support them, how we can make reasonable adjustments. So ultimately, we want to make sure that we are meeting with them and examining those reasonable adjustments. Now, they are refusing to come back because of their disability. Potentially that turns into a sickness absence, and potentially we request that sick note once they've been off for 7 days and look at managing it as a long-term sick process. But to answer your question, unfortunately, it's a case-by-case basis. You have to really look at what is the employee's issues, what are their concerns, how do we alleviate their concerns, and more importantly, how do we document what we've done so that if 6 months down the line we're at a tribunal, that we can show that tribunal that we did everything above board and we followed the correct process with it.
Right, but question here is if, well, I understand it's on a case-by-case basis, but in kind of an extreme scenario where an employer, especially small business, who can't really afford having people staying at home and paying them full salary, I keep in mind the fact that furlough will eventually end. Is there a possibility to move an employee who's like persistently refusing to go back to work on an unpaid leave, or start a dismissal procedure without, saying that all the risk assessments are done, that there is a reasonable contact from the employer side? I understand there should be a route which would allow an employer to, seize that responsibility for paying their salary to someone who is like persistently refusing to return to work.
Well, I mean, if we get to a point, so let's say we're in that scenario there, so that we've addressed their concerns, we've addressed the health and safety element of it, we've dealt with all reasonable adjustments we possibly can, and this employee is just refusing to work, and working from home just doesn't work for us. We can't do that. So we're in a position where we're in a corner with it, then yes, we are in a position where we can look at a dismissal. But it is worth noting that in those situations, there's so much groundwork to lay to make sure that that dismissal is ultimately one that is fair, and ultimately one that can't be twisted into a disability discrimination claim. In extreme circumstances, you may dismiss, yes, because ultimately it becomes an unauthorised absence. They're AWOL, they're refusing to come to work. And ultimately what you'd be doing is dismissing them because they have a disability and they're refusing to come to work because of it. They've got an underlying health condition. It is possible to dismiss employees in those situations, but I would always recommend take legal advice, make sure you're guided through that process, because, a discrimination claim is uncapped. I mean, some claims I can sit here and say, this is how much it could possibly be. And obviously we'll do everything we can to mitigate it down. But with a discrimination claim, it's so high risk because of the nature of the payout as well. It's uncapped and it's through the roof and beyond. So when you describe those smaller businesses there with just that one employee, for them, it really is weighing up the risks between, do we become a bit more militant? Do we push this employee? Do we get them to a point where we want to dismiss them and take that risk? Is that worth the risk to the business? Or do we lay the groundwork, take a little bit more time with it, make sure that we close all those doors essentially to any claims, so when we finally dismiss that employee, it's just safe to do so. Does that?
Right, so, yes, absolutely. So ultimately, taking legal advice can potentially save thousands of pounds, especially in this area, which is still quite new. I understand. Yes.
Tens of thousands, even hundreds of thousands of pounds when it comes to discrimination claims. Absolutely.
Right. And so when we are around this topic of, people shielding, we have this hot topic of vaccinations right now. So vaccination rollout has started, and some employers admitted in the media that they will not employ people who are not vaccinated. How does it work? Is it legal in the UK to put this kind of, requirement in the employment contract? Also, what about existing employees? Does the employer have a right to enforce vaccination onto its employees?
So it's a very interesting question, and it's a difficult one at the moment, a really difficult one. And the reason being is, the last year has been unprecedented. It's been unprecedented socially. We're obviously all restricted from each other, but as well as that, it's been unprecedented employment law. A lot of this, there's no case law to back up employers' decisions. So, for example, there's little case law to back up someone being dismissed for not wearing PPE, or being dismissed because they feel that coronavirus is a hoax, for example. Now, whether that will amount to a philosophical belief or not hasn't been tested. So we've got to be very careful and very mindful of that when it comes to enforcing vaccination policies. Our advice to clients at the moment is obviously be cautious, but encourage employees. Take the approach of having a policy, a clear policy that's well worded, that you encourage employees to take the vaccination, and not yet be so heavy-handed as to force employees to take the vaccination. Now, Matt Hancock did say last week that they are exploring making it mandatory in some industries, like care industries, making nurses in care homes mandatory for them to take the vaccine. Now, of course, he will have to consider whether that's a blanket approach and who is that going to impact. If you imagine ethical vegans, for example, which is now protected as a philosophical belief, some vaccinations are made with egg whites. So you'd be forcing a vegan to put egg whites into their body, which again could amount to an easy discrimination claim. As well as that, pregnant employees, obviously we're always cautious of pregnant employees because of the risks involved to them and their child. but we're going to be very cautious of forcing pregnant employees to take the vaccination, because of course, if anything goes wrong there, the employer does not want to be liable for that. As well as that, you don't want to injure an unborn child or a pregnant lady. So we've got to be very cautious of that side point. Our advice is put that policy in place, make it very clear, make it very robust, and then, as we've said before, deal with things on a case-by-case basis. That way it shows that you are navigating risks, that you're responding to the issues that your employees have. I mean, the main risks of any vaccination policy, if you enforce it, is one, what are you going to do if they don't take it? Are you going to get yourself to a point where you dismiss these employees? And if you do, is that really going to stand as a fair dismissal at a tribunal? The second one is if you enforce it and the employees don't want to do it, and they do it anyway, and they feel that's a fundamental breach of the trust and confidence in the contract, they resign and go for constructive dismissal. Got another claim there. And then the third one, as we've covered, is the discrimination element. So these companies out there that are being very robust in their approach, like Pimlico Plumbers have said, you know, no job, no vaccine, or no vaccine, no job, sorry. We want to make sure that don't be too militant in your approach. Make sure that you are encouraging staff, not forcing staff, because there's no case law to back up that we can force staff to take a vaccination. And I think even if Matt Hancock does say in the care industry that they are going to force staff to take the vaccine, there will be cases where they will have to bow down and say, okay, that employee will have to be let off not taking the vaccine because of their religious beliefs, or because of the fact that they're pregnant, or perhaps existing health conditions, which means they have reacted poorly to vaccinations in the past. So there's just so many variables with it, but it does all start with a policy that really does outline all of this.
Coming back to the question, but okay, I understand that, well, employers, they have to be very careful when it comes to the vaccination policies, but would it be possible for an employee to, let's say, refuse to come to work if some of the colleagues didn't get vaccination? So let's say an employee, he could feel insecure of working with non-vaccinated colleagues. How this issue could be addressed by the employers?
We'd have to deal with it. I mean, obviously, an employee has a statutory right to raise a grievance. So at the end of the day, they're entitled to that grievance procedure. So any concerns that an employee puts forward, we want to make sure that we're dealing with it as they want it to be dealt with. Are they raising a formal grievance? Are they being informal in what they're saying? So that'd be step one for me, is let's just make sure that we manage this through the correct process. And secondly, obviously, it's dealing with their concerns and giving them an outcome to it. Now, again, this just highlights the minefield that vaccinations bring. If an employee is saying, I'm refusing to come in because other employees will not be vaccinated, well, we can't force other employees to be vaccinated. We can't force them to be vaccinated, so that becomes an issue. So I'd say deal with it on a case-by-case basis. I mean, there's always the possibility of looking at reasonable adjustments. Can we change hours? Can we make it so that they work not necessarily on their own, but in a separate office, so that they're not necessarily next to each other? I mean, one key point to outline in the response to that employee would be, look, coronavirus is here. Unfortunately, it is here to stay. And regardless of whether we have vaccinations or not, we still have to maintain social distancing at work. We still need to wash our hands. We still need to be cautious of this. So there's still that element to pull on as well, which is, look, if you are concerned about health and safety in the workplace, this is what we've done. We're dealing with your concerns, but here it is. Here it is outlined, everything we've done in the workplace to keep you safe. And at least then, if that employee resigns, goes for these claims, they go for constructive unfair, or they attempt that claim under Section 44 that I outlined earlier, you can at least show that tribunal that you've done what you can to accommodate that employee, that you're in a position where you can't necessarily, or don't want to necessarily, force other employees to take the vaccination, and that you've done everything you can to deal with their concerns, to make the workplace as safe as possible. And at least in that situation, you'll be able to hold up your hands and ask that judge, you know, what more could we do within this situation? And that's always a strong place to find yourself in.
And maybe, like, slightly, well, related to the subject, but slightly different question. Can business refuse to serve non-vaccinated customers? I mean, I, as a business owner, as an employer, let's say I'm concerned about my employees who are all vaccinated. Can I make such a statement that, well, in the future, probably with the introduction of some COVID passports, there are those ideas around, would it be possible for employers, I mean, business owners, to put such a restriction that only vaccinated customers can be served.
I mean, I want to be cautious with that. I mean, obviously that steps slightly out of employment law for me, but in terms of discrimination, I mean, the Equality Act, that covers more than just employment, it covers everything. So that would apply in this situation. So all those risks I've outlined as to reasons why they may not be wearing or taking a vaccine, then that applies. Like we had with wearing masks previously. A lot of people came forward with justified reasons for not wearing masks. They have asthma, or they've been victims of attack and they don't want to wear these masks, and that's justified reasons for not doing it. So as a business owner, you want to be cautious of any blanket rule like that, because that could be indirect discrimination, which is essentially where you have a policy or procedure which you apply to everybody that has a disproportionate impact on one group. So you want to be very cautious of that. The other thing I'd say on this is we all just have to watch this space, really. I mean, Boris has said that there may be vaccination passports, that pubs may ask for vaccination records. So in terms of that, you know, the government is likely to give us more guidance on this prior to all the country reopening and us hopefully getting back to some level of normality. So I'd say just be cautious. One, of the discrimination element of it, and two, what guidance will come out in the future.
Okay, so if I understand it correctly, well, just don't jump ahead of the queue and create your own strict policies before the government guidance will be clearer, if I can say it.
That's it. I mean, we've had to say this a lot over the last year. We don't want to be the test subject. I mean, in some cases, okay, it's in extreme circumstances. We have a care home, for example. We need to take extreme steps to protect people. But what an employer doesn't want to become is that test subject, because when you're written into case law, you're written into history, and you were the ones that were made an example of.
Right. Well, my understanding here is just to make sure that, well, risk assessment policies are updated, they're up to date, they're reviewed, employees are aware of them, ideally probably signing them. Just employer does everything that is reasonably possible to protect staff. However, of course, employer has a duty to protect business as well, and the business needs. So just to find this on, find the right balance and just do everything that is reasonably possible to make workplace COVID secure, and to look on that case-by-case basis wherever any issues arise, and trying to first of all just find a solution that would work for everyone. But in the most extreme cases, it is my understanding right now, thanks to you, Mark, and thanks to Darren, that in the most extreme cases, it is not only an employer's duty, employees also have duties, and they can be reasonably expected that they have to they have to comply with the work requirements, not only have, in some extreme cases, some unreasonable demands, like, I would like to stay at home even though that I cannot work from home. That wouldn't be possible in some cases, and employers have some space to move around those issues, and, well, in extreme cases, even dismiss an employee.
That is right. It's all about making sure you lay that foundation before you go in and tell that employee that. So let's say you do have an employee that's being difficult. We are going to look at dismissal. Say very bluntly, we expect you back at work tomorrow. If you don't come back, it's going to be an authorised absence. In those situations, there's just foundation to lay. You want your policies clear, you want your contracts to back you up, and you want to make sure that your process has been followed, so that at that point where you make those decisions or inform that employee of that, it's just safe to do so. You've got backing to do it, so that if that employee just decides, okay, I'll go for a tribunal claim, see you later, and resigns, you've got something to fall back on then to justify your actions, your process, and why you did it.
Right. And so, well, connected to this, it's the topic of employees who wish to stay on furlough, because at the moment still furlough scheme exists in the UK. And when some employers have a work available, some employees they deny to return to work, for example, on the basis that they are shielding. What are the employer's rights to request someone to end furlough, even in those cases when someone is really extremely afraid of going back to work due to COVID?
And in terms of furlough is a contractual agreement between both parties. So the employer is agreeing to it, and importantly, the employee is agreeing to it as well. So in our letters that we send out to clients for them to use on furlough, which has been updated several times over the last year, given all the guidance that's changed over the previous year, we very much form it as this is a contractual agreement between both parties, which means technically The employer can bring it to an end, and technically the employee can bring it to an end. An employee can turn around and say, I don't want to be on furlough anymore. I'm bringing this agreement to an end, and so can an employer. Now, it's interesting what you said, you know, if there's work available, what we don't want to do is get into a position where we use furlough, we shouldn't have, and then HMRC is coming, we have an investigation, we can't justify it, and we're looking at having to pay back everything that we've received for furlough payments. So we want to be very cautious of that element of it. My advice would only be to use furlough if you can hit that definition, which is the work has been impacted because of coronavirus. Okay. Even if an employee refuses to return, I mean, we're back to the same advice around shielding, really. It's looking at what are the concerns? Why are you refusing to return? Is there a health and safety concern there? Are we dealing with this in the correct way? Are we listening to your concerns, and are we managing them in the right way, basically? In some cases, and you'll find this with furlough, it's less extreme as shielding because there's less likely to be a discrimination risk there, if that makes sense, because we're shielding, they're off because of a health reason at the end of the day. I mean, with furlough, you may find that some employees just want to be off. I mean, if I'm honest with you, in the beginning, we thought it'd be difficult to get employees to agree to being furloughed, but it has actually proven to be more difficult getting employees to come off furlough and come back to work. Now, if you're in that situation, I mean, again, you can lay the groundwork to get yourself to a place where you can say to that employee quite clearly, you come back tomorrow, or it's an unauthorised absence. Okay, so you're in a place where you can then look at it as a conduct issue, but it's just, again, ticking those boxes to make sure that any other claims can't be brought. Does that make sense?
It does make sense, yes. Thank you very much. Thank you very much for that. I mean, I think that we've covered most of the things that I really, wanted to ask you about. However, if there's anything that you would like to add to the subjects that we touched, I'd like to hear from you and from Darren.
Absolutely. So I'd just like to give some advice and tips really from what I've seen on the health and safety side. So just going back to the COVID-19 risk assessment and the policy to accompany that. A lot of companies I see forget about the mental health, the general well-being, because obviously employees are in some form of isolation, being at home. So you need to think about this then ties into lone working as well. What can you put in place where there's regular contact? But how are you managing those employees that have got mental, that are suffering from some sort of mental health working from home? So one good area that it's a product that we offer, but it is widely out there now, and that is an employee assistance program. We recommend employee assistance programs now, and it ticks two boxes. It ticks the stress policy under health and safety, and it also provides that well-being framework, should we say, for employees that are suffering. Now, an employee assistance program, it's not very expensive. It's a benefit that an employer gives to an employee, but it's a 24/7 counselling framework, and we're counselling for mental health, general well-being. The employee maybe could be getting abused in their home, for example. Okay, but it's all support around that's going to be invisible to the employer. The other areas that I've probably talk about as well is, so within that policy, it's probably, so ACAS are a big believer of this as well, is when an employee is at home, if there is any sort of abuse going on of some sort, okay, maybe think about code words that the employee could give, for example, for when they're speaking to the employer. And these are sort of things really should be in a policy. The other area as well is for any clients of yours that are opening soon, okay, think about the testing facilities. Obviously, you've got the fire alarm testing, you've got the general sort of fire extinguisher checks, etc. But think about Legionellas, because if you've obviously got hot water that's now warm water just sitting there for months and months and months, okay, have procedures in place to flush all the pipes, to get all that water out of the system, to remove that risk of catching Legionella.
Right. So, this is regarding empty office spaces, for example, right? Just to make sure that that is done. But what you mentioned about mental health, that is very interesting topic, because yes, I think that's, well, extended lockdowns, that could be, well, increased risk of mental issues and employees not being able to see other employees, being in a same environment all the time. I think that it could be extremely beneficial for certain companies to offer to their employees this kind of consultancy with professionals, that their employees would have a free access to that kind of a professional help. Is definitely something that many employers should consider. And also, when you've mentioned about health and safety, I just wonder, because that question just came to my mind right now. When an employer has employees who are working on the computers provided by the employer, let's say, we know that the electronic equipment should be tested, once per year. You've mentioned that at the beginning. If I'm right, it should be tested once per year. So how does it work if the equipment is provided for the employees, or if employees work on their own computers?
Okay, so that's a good one. So this obviously to get picked up in the home assessment. In a perfect world, the employer would be providing the tools for the employee to do their job, and those tools obviously got to be safe for the employee to use. What an employer, if that is not possible, and the employee is using obviously their own laptop and stuff, you've then got to think about the vulnerability, say, of the data. So any data breaches, any security leaks. I guess is there a VPN in place that the employees can use when they're going into the office server, for example? Again, it all comes down to the risk assessment. The home assessment should pull this up, but it's all should be in the policy. So it all should be thought of, because obviously there's a lot can go can go wrong.
Yeah, but I mean, for example, if an employer provides an employee with an electronic equipment to just check if it's safe from, just electricity point of view, I know that those checks are being done on computer equipment quite regularly. Would that mean if the equipment is provided, employer has some duty to collect it, let's say once per year, to do some testing? Is that something that employers should be doing?
Yeah, absolutely, and that should be in the IT policy, because that's generally working from home anyway. Especially if you're a field engineer, or generally you are regional, don't go into the office. Absolutely, but again, it all comes down to policy. You're setting the expectations. You're setting the rules for your business. We speak to businesses day in, day out, and it's surprising the amount of businesses that don't have a handbook in place. That is just as important as the contract, and that's obviously where all these type of policies should go.
Why is handbook so important? Like, if you can just guide me through this, because you mentioned it is so important.
Yeah, I mean, I can cover that. I mean, obviously, your contract has your contractual terms in it. Now, how we recommend doing things is you keep the minimum in the contract that you need to make it binding. You give yourself a few more clauses to give yourself flexibility, and then put emphasis on your handbook, which you make non-contractual. Now, your handbook is essentially your rule book. It's what you expect, or how you expect your employees to behave, the processes that you'll take them through if they don't behave, or if they've got concerns, how you will deal with them. If they are absent, for example, when they're going to call in by, what you're going to do if their absence levels get so high. So it just basically lays the foundation of the rules and expectations for the employee. I mean, you can have policies like tattoo policies. For some industries, they may find that they don't want employees to show tattoos, so therefore you put that in your handbook, or a uniform policy. Now, the benefit of not putting it in the contract is it's non-contractual, so we make sure it's very clear that it's non-contractual, which means as an employer you can update, you can amend it. So let's say your absence policy says your staff need to call in by 10 a.m. in the morning if they're sick, and you don't like it, it doesn't work for you, you want them to call in at 8 in the morning so you can move things around. Now, if that's in a contract, that's a lot more difficult to change. You're into the realms of consulting with those employees or changing their terms and conditions. If it's in a handbook, you amend that policy. You make very clear that we've updated the policy, this is now what it says. And further to that, if we get to a tribunal, for whatever reason, obviously we always look at that. That's how we operate within employment law. It's always got to be, if we're at a tribunal, how do we justify our actions today? Let's say we picked up an employee for not calling that absence line for the correct time, or let's say we picked up an employee for being late too often. Now, one thing that's really going to go in our favour is, because the tribunal is going to ask us, where have you written this down? Where is your foundation to these rules? Now, have you informed these employees that this is what you expect of them? Have you informed these employees that they need to call in by 8 in the morning? And we stand up and say, no, we've got no evidence to write it down, no evidence written down, no evidence to put forward. It puts you on the back foot. So there's a lot of emphasis on the employee handbook. And as well as that, the employee handbook reflects the ethos of the business. It reflects how you want your employees to represent you as a business. It reflects how you want to be represented. Everything goes into that handbook. So there's a lot of emphasis on the importance of it.
Right, thank you very much for that. Well, thank you very much for answering all the questions. It was very interesting to hear how the situation develops, especially around COVID-19 and all the changes that we are experiencing at the moment. And I understand that we'll be looking forward for the more guidance from the government, and certain things can change. Certain policies will need to be updated. It's really good to keep an eye on those and keep an eye on the new government guidance, especially with the rollout of the vaccination and vaccination passports, etc. So topics that we touch at the moment. But it's really good to know that going forward with too strict policy would risk discrimination claims as well. I think this is a very, very important message, and it was great to know that. It is important, of course, to keep the risk assessments updated. That is a very, very good guidance, for all employers. Well, thank you very much for today. Thank you very much for attending. And Mark and Darren, thank you for your input. It's been a pleasure.
No problem.
That's great. It's been very enjoyable. Thank you, Thomas.
Okay. Thank you all attendees, and thank you for joining us today, for joining us this morning.